Welcome back to Glitch in the Matrix, the Apocalypse. This is your host again, Ali Taj Bey. Let's show you how you can stop garnishments. Everybody has to hate garnishments. Taking money out of your check that you need to survive, to take care of your family, and handle other obligations. Well, this won't only stop garnishments, it will stop evictions, all collection actions, repossessions. They will not be able to repossess your vehicle. And in most cases, if I'm correct from my studies, if they take it, once you have a bankruptcy in place, there's also penalties for it. I'm going to go over that at the end of this video for anybody who violates a bankruptcy order. So this is funny. A lot of people have been incorrectly informed that you should never file bankruptcy. And for the most part, the average American is terrified to file bankruptcy. So once we get into this video, you'll understand why you were told to stay away from bankruptcy. So again, this is like a get out of jail free card in the game of Monopoly. This is not something that you can do every couple of months or, you know, uh, every year or something like that. This is not one of those cases. This is for in school, break glass in case of emergency. So I'm going to show you how to protect yourself, protect your assets, and how to use bankruptcy to your benefit. So basically, let's get into right here. I'm going to get this big enough so you guys can see it. So wage garnishment and bankruptcy. Wage garnishment occurs when a court issues an order that requires your employer to withhold a portion of your paycheck and send it directly to a person or entity to which you owe money. Generally, garnishment lasts until a particular debt is fully paid off. The debts for which a wage garnishment order may be entered include child support, student loans, taxes, and any debts that have been the subject of a collections lawsuit, emphasis on lawsuit, resulting in a judgment against you and a wage garnishment order. Many times when I consult with some clients, it's always being brought to my attention that people are not getting judgments. They're skipping that part and going straight to um, wage garnishment. So as you know, this is a due process violation, and they are violating. They're supposed to go to court first and get a judgment against you. So resulting in a judgment against you and a wage garnishment order. These are what is necessary before garnishment can ensue. Except in cases of child support, student loans, and taxes, a creditor cannot garnish your wages without first suing you. So those are the exceptions. It's child support, they don't need a court order. Student loans, they don't need a court order. And taxes of any kind, whether it be federal, state, local taxes, they do not need a court order before they begin garnishing. So a creditor cannot garnish your wages without first suing you, winning, and obtaining a court order signed off on by a judge. If a creditor wins a lawsuit and a money judgment is entered on its behalf, the creditor can garnish your wages by giving a copy of the court order to the local sheriff. So this is almost like doing math. When you want to check your math, you do everything in reverse. So if you are having issues with a garnishment, this is who you want to contact. Let me grab this a little more. So this is who you want to contact in regards to that, to get a copy of the order and to make sure that everything is legit. Who then sends it to your employer. Federal and state regulations govern how much of your paycheck may be garnished. Under federal law, the lower of 1 up to 25% of your disposable earnings. It's not all your money, but your disposable earnings, whatever is left after you subtract your liabilities. So, or 2, the amount by which your weekly income exceeds 30 times the minimum wage may be garnished. However, in some states, a lower percentage limit is set for the amount of your wages that can be garnished. Different rules apply to child support, student loans, and taxes. So I'm going to greatly assume that these would fall under your federal guidelines because these are all federal issues right here. Well, except for child support. Um, Child support is issued by the state, but I actually, again, believe this is a federal issue. But student loans, unless they're private, yes, they are a federal issue. Your employer may not retaliate against you because your wages have been garnished to pay off a single debt. However, under federal law, you are not protected against retaliation when more than one creditor has garnished your wages or your wages are being garnished by a single creditor for two or more debts. Some state laws provide more protection against retaliation. Fighting wage garnishment. You can protest the wage garnishment by filing papers and proving to the court that you need more of your paycheck to pay off your expenses or that you qualify for an exemption. If the judge will not terminate the garnishment, in some cases, filing for bankruptcy can stop wage garnishment. So, as I said, this is a get out of jail free card. This is not something that you abuse. It's not set up like that. This is something that if you really get in a jam, so I would just advise just being more, what's the word? I guess responsible in your dealings and maybe make some changes in how you're spending your income or what you're using your income to actually pay for. I'll probably say that. However, you should be aware that bankruptcy will not stop garnishment of child support or other non-dischargeable debts. And again, there's a remedy for that. I'll probably do it in another video, but non-dischargeable debts can be challenged as non-dischargeable, which makes the person making the claim prove that they are non-dischargeable. So once you file for bankruptcy, an automatic stay will go into effect. And that's why I said in the title, this can be done in less than 24 hours. It all depends on how quickly you can obtain all the information needed to fill out the bankruptcy forms and schedules to put this together so that you can get this petition into the court and get a docket number. That is all you need is a docket number, and an automatic stay will go in place. Once you get notice of this docket number, you can serve this docket number or notice of filing on any creditor who may be attempting to collect on you, repossess a vehicle, evict you, what's the other one? Foreclose upon you. All these things can be stopped just with notice of the bankruptcy, and you want to have proof. So you want to send these. If you have email contact with these, whatever creditor, send it by email. If not, I wouldn't suggest doing this in person and just handing it to someone. You want to have evidence. So I would send it certified mail, return receipt requested, have them sign off and send both to you. So you'll have proof of mailing and then you'll have proof of receipt when you get your return receipt back, which is the green card that you get from the United States Postal Service. You can give notice of the bankruptcy to your employer's payroll department, as well as the levying officer handling the wage garnishment. In most cases, that would be the sheriff. An automatic stay will not affect child support or alimony, since these are priority debts that are non-dischargeable. Again, as I said, these are not written in stone. They too can be challenged, and you can make the creditor prove the non-dischargeability of the debt that they are claiming. When any creditor that is affected by the stay wants to continue its collection efforts, it must prove to the court that there is good cause to lift the stay. Generally, unsecured creditors that want to continue garnishing your wages cannot present good cause to get a stay lifted, other than when the bankruptcy court lifts the stay on a creditor's motion. An automatic stay will end when you receive a bankruptcy discharge or when the case is dismissed without a discharge. If the debt at issue was included in the discharge, the creditor will not be able to resume wage garnishment. However, if you do not get a discharge, the creditor can continue wage garnishment In some cases, you can recover back wages that were garnished within 90 days prior to your filing of bankruptcy when they are over $600 altogether and you have exemptions that cover them. So that's a beautiful thing about this bankruptcy procedure or proceeding. So let me go here. And this is from a law firm's basically. So I guess they help with debt collection and relief of. So let me go here. We're going to read this real quick. I'm going to let you know about the automatic stay that we were just discussing. So what is the automatic stay in bankruptcy? The automatic stay in bankruptcy provides one of the powerful protections for a consumer given by the Bankruptcy Code. What is it? Under the Bankruptcy Code, Title 11, United States Code, Section 362, the filing of a bankruptcy under any chapter of the Bankruptcy Code automatically triggers an injunction. So that's what I said. All that is needed for this to work is notice. The bankruptcy court and clerk will give notice of all the creditors that you list. But however, it may take time for them to get, especially if these notices are being mailed out. If you have a faster way of getting notice of this, of your bankruptcy, whether it be call in and then follow it up, ask for an email address, or mail it. So you want this to get in place fast, especially if you're receiving calls and you're getting threatening letters or stuff like that for collection of debts. So the automatic stay goes into effect to prevent nearly all collections the day you file your bankruptcy case. The automatic stay stops foreclosures. The automatic stay stops lawsuits. It stops garnishments. It stops the phone calls from bill collectors. It prevents repossessions. The automatic stay tells all your creditors, time out. This is a timeout. Do not pass go. Nothing else under the law is as powerful a tool to stop collections. The debt settlement industry cannot promise any such protection. They can't stop your creditors from calling you, suing you, or garnishing your paycheck. They can only ask them to stop. With the full force of federal bankruptcy law behind us, we can force bill collectors to stop. Attempting to get some deal by private arrangement with your lenders and creditors may work sometimes. Bankruptcy protection, on the other hand, offers the protection of the law behind it without having to bargain. And even if you do manage to settle a debt outside of bankruptcy, the canceled amount of your debt may even increase your taxes. This is because when a creditor agrees to accept less than the full amount owed on a debt, that creditor must report the canceled debt to the IRS on a Form 1099-C, which is added to your income for that tax year. Bankruptcy will never raise your taxes. Automatic stay is only available with bankruptcy protection. No debt settlement or debt consolidation companies can't promise the protections from creditors that bankruptcy law already gives you. No debt settlement company advertising that you should avoid bankruptcy can offer you the protection of the United States Bankruptcy Court and the automatic stay. Your creditors are free to sue you, foreclose on your home, levy your bank account, call you nearly every hour while your debt settlement company tries to work something out with their creditors. We don't need to beg your creditors to work something out. Consumer bankruptcy is not negotiation. If you're eligible for Chapter 7 and don't possess assets over the exemption limits, you can discharge all your dischargeable unsecured debts without any negotiation or any payments. If Chapter 13 is better for you, many, if not all, general unsecured debts may still be discharged without any begging. We don't have to negotiate. We have bankruptcy law on our side. And if your debt is discharged in bankruptcy, you won't owe any taxes on the discharged debt to the IRS as you would through debt consolidation under a 1099-C, which is a cancellation of debt. What does the automatic stay do for me? Simply put, the automatic stay is a tremendous tool for debtors in that it serves to prohibit most contact and continuing collection activity from the creditors on debts while your bankruptcy case is pending. For example, the bankruptcy automatic stay prohibits nearly all creditors, including collection agencies, from corresponding with you at all. including phone calls, demand letters, bills, etc. Any creditor from starting or continuing a lawsuit against you, car repossessions, foreclosure proceedings, and trustee sales, wage garnishments, or bank levies. Even if garnishment orders are already in effect, it still stops them. There are a few exceptions in which the automatic stay in bankruptcy cannot help you. These include items such as certain tax audit proceedings with the IRS and support actions such as collection of child support or alimony. To immediately stop the harassing phone calls, lawsuits, and other collections against you, contact a bankruptcy attorney right away for a free consultation. Or if you're capable, you can file these forms on your own. They do come with instructions and they can be found. Most times you want to find them in the district where you're at, but I'm just going to show you real quick how to find these forms. And it's probably going to be in my, all right, so right here. So U.S. Courts bankruptcy forms is where you want to go. You go here, and this will bring you, this is for all U.S. courts, and they are universal forms, so they should be accepted wherever you're at. And this is what you want to file. This is the first one you need, is a voluntary petition for individuals filing for bankruptcy. Trying to remember the other ones. And there's just a couple that you need to actually get the case started. So I'm going to show you real quick. Oh, hopefully I didn't pass it. And these are the different forms. So, you know, under Title 12, under Chapter 12, sorry, 11, 13, it depends what you're filing. You would grab the appropriate form. But there is another form that is very important when you're filing with your petition. I don't know if I passed it already. So it must be down here. Sorry about that. I don't know why. I can't find the form. I'm trying to go as slow as possible. But there's about 4 forms that are necessary to actually open your case and get a docket. So I'm trying to locate that for you so this will make it easy on you. I don't know, didn't see it. So this is for chapter 7, so there should be another one in here as well. But if you don't want to pay the fees up front, you can file to have them waived. This is for chapter 7. It seems like some things are missing here because I'm not seeing the other form you need either. And it should be in here. And then most of the other forms will be due after your filing. You will get a deficiency notice and you will have 14 days from that notice in order to correct the deficiencies. And they will actually list which forms are missing and that need to be filed still, or your action will be dismissed and all collections will again resume. All right, if I don't see it here, I'm just going to search it manually and I'll show you what that form is. Because I'm looking very hard and I don't know how or if I'm missing it. Yeah, I don't see it. All right. So, all right, so this should be it right here. This is one of the other forms that you'll need to file with it. So you'll start here. Okay, yeah, it does have it. So you would pick your court. That's why I said these forms are universal and they're fillable online. So pick whatever court that you're in. You don't have a case number yet, so you'll leave this blank. Then you'll go in, fill out your whole name, middle name, last name, your social security number. If you don't have one, you would click here. And this is for ITIN. These are for international tax identification numbers. This is basically if you are not a US citizen and you had to apply for an ITIN number, you would put those numbers there. You would sign here under penalty of perjury. You would date it. And then this would get filed with your voluntary petition and your fee waiver. And that is everything that you need. So that concludes today's video. Again, I'm your host, Ali Taj Bey. This is The Glitch in the Matrix, the Apocalypse channel on YouTube. Be sure to subscribe, like, share, and comment. Thank you. Peace and light.